Who can be appointed as an arbitrator? Section 2, subsection 1, clause D defines the term arbitral tribunal. Accordingly, arbitral tribunal means a sole arbitrator or a panel of arbitrators. Section 10 and Section 11 of the Arbitration and Conciliation Act 1996 provides for composition of arbitral tribunal. Section 10, subsection 1 provides that while making an appointment of arbitrator, parties to dispute are free to determine the total number of arbitrators, but such total number of arbitrators shall not be an even number. The total number of arbitrators appointed by the parties must be an odd number. According to Section 10, subsection 2, if the parties to arbitral agreement fail to determine the total number of arbitrators, then the arbitral tribunal shall consist of only one arbitrator or sole arbitrator. The arbitrators to be appointed for an arbitral proceeding must give their free consent to act as an arbitrator, to adjudicate upon the dispute which is the subject matter of arbitration agreement. Section 11 of the Arbitration and Conciliation Act 1996 provides for the appointment of arbitrators to conduct the arbitral proceedings on reference of a dispute for adjudication. Section 11 of the Arbitration and Conciliation Act 1996 lays down that a person of any nationality may be an arbitrator unless otherwise agreed by the parties. Subject to the provisions of Act, the parties are free to agree on a procedure for appointing the arbitrator or arbitrators. If the parties fail to determine the procedure of appointment of arbitrator, then if the arbitration is with the three arbitrators, each party shall appoint one arbitrator, and the two appointed arbitrators shall appoint the third arbitrator who shall act as the presiding arbitrator. If a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, or the two appointed arbitrators fail to agree on the third arbitrator within 30 days from the date of their appointment, in such situation the appointment shall be made upon request of a party by the Chief Justice or any person or institution designated by him. Where under an appointment procedure agreed upon by the parties and a party fail to act as required under that procedure, the parties or the two appointed arbitrators fail to reach an agreement expected to them under that procedure, or a person including an institution fails to perform any function entrusted to him or it under that procedure, then a party may request the Chief Justice or any person or institution designated by him to take the necessary measure unless the agreement on the appointment procedure provides other means for securing the appointment. A decision on a matter entrusted on the Chief Justice or the person or institution designated by him is final. The Chief Justice or the person or institution designated by him in appointing an arbitrator shall have due regard to any qualifications required of the arbitrator by the agreement of the parties and other considerations as are likely to secure the appointment of an independent and impartial arbitrator. In the case of appointment of sole or third arbitrator in an international commercial arbitration, the Chief Justice of India or the person or institution designated by him may appoint an arbitrator of a nationality other than the nationalities of the parties, where the parties belong to different nationalities. Where more than one request has been made to the Chief Justices of different high courts or that is their designates, the Chief Justice or his designate to whom the request has been first made under the relevant subsection shall alone be competent to decide on the request. In an international commercial arbitration, the reference to Chief Justice in those subsections shall be construed as a reference to the Chief Justice of India.